I want to start by thanking World Can't Wait and thanking Deborah Sweet for inviting me to be here and for being such an ally to the Center for Constitutional Rights where I work, in our work and in trying to give visibility to the cases that we work on, which have not gotten, in some ways the attention they should be getting and generating the discussion they should be generating. So I really thank you all for that. And I also want to say how motivating and encouraging it is for me to be here sharing this event with Ethan, who I heard speak in Albany at the anti-war conference a few weeks ago, and was really impacted by the video, which I had seen before and had read about, but it's different when you see it the way you'll see it tonight, and hearing him speak. And before I get into the case, I just wanted to say a few words about the obvious importance and courage that it takes for people like Ethan and for other soldiers and for people within the system to come out and speak out about what they know and what they're seeing. It makes people pay attention in a different way, in a way that groups like Center for Constitutional Rights can't always get people to pay attention. And when I was thinking back over how dissenters and whistleblowers from within have made a difference in our work, one obvious example is in the Guantanamo cases, which are the cases that I started out at CCR focusing on. The case of Boumediene versus Bush, which was the Supreme Court case in June of 2008 that basically established the right of detainees, the constitutional right of detainees at Guantanamo to challenge their right through habeas corpus. The reason the Supreme Court essentially decided to hear that case was because of a declaration filed by an officer who was part of these military tribunals that were reviewing the status determinations by the Bush administration. And it was because of, his name was Stephen Abraham, and he got a lot of attention back in 2007 and 2008 because of this declaration that he wrote, essentially talking about the flaws and the inadequacies of the combatant status review tribunals. He filed that declaration in one of the cases that was going up to the Supreme Court. The Supreme Court in April of 2007 had denied the opportunity for those detainees to be heard at the Supreme Court level. They'd lost below. In June, Stephen Abraham filed this declaration, and literally a week later, the Supreme Court reversed its denial and decided to hear the case. And that is really why things played out the way they did, and why there is a constitutional right to habeas for detainees at Guantanamo. And as we know from the cases that have been heard so far, the majority of them, judges have found the detentions to be unlawful, and that decision really broke open the system in a certain way. So that was Stephen Abraham's role in that was absolutely central. And then the other case that Deborah mentioned is a case that we have at CCR on behalf of the families of three men who died in June of 2006 at Guantanamo, two Saudi men and a Yemeni. As Deborah said, the military and the government characterized those deaths from the beginning and continue to maintain this position until now that they were suicides, that the men were found in their cells hanging from nooses. They came out the day after the deaths and called them asymmetric warfare, a good PR move. Didn't really say or provide any information after that point for 2 years. 2 years later, the military released its investigation, its so-called investigation into the deaths, made the same conclusions. We filed a case on the basis of that report because that's all the information we had in court on the premise that even if they were suicides, these men had been tortured, they'd been arbitrarily detained, and there was still responsibility by the U.S. government for what happened to them. And then in January of 2010, this is almost 4 years after the deaths, 4 soldiers came forward. And they basically said they came forward because they couldn't stay silent any longer. And their consciences were weighing on them. And they basically provided accounts that went directly against what the government and the military had been saying for 4 years about these deaths being suicides. They said that they had been told by their commanders and their superiors not to contradict an account that would be given to the press that these deaths were suicides and that the men had been found hanging in their cells from nooses, not to speak out. One of the facts that the government had in their report was that the men died in their cells and were taken directly to a medical clinic. These soldiers said, that night we never saw anyone going from the cells to a medical clinic. There was not any traffic in that direction. What we did see was a transport van that carried detainees to and from their cells to interviews with their lawyers. We saw that transport van drive up to the facility where the men were being held, take men one at a time into the van, drive in the direction of a secret facility at Guantanamo, informally known as Camp No. And then from there, we saw that van back up to the medical clinic and unload bodies. That's the traffic we saw, not from the cells to the medical clinic. That evidence suggests that the men did not die, strongly suggests they didn't die in their cells. They died at Camp No in this facility and were taken to the medical clinic, and there a story was fabricated. At the very least, if you question that theory, what seems very clear is that there's been some kind of a cover-up and that we don't have the full story. So we filed a new petition, a new motion in the court on the basis of that new evidence, which we wouldn't have had if those soldiers, and one of the main guys who came forward, his name is Joe Hickman, wouldn't have had if they hadn't come forward. That case is now pending in the courts. It's been dismissed. We're going to appeal. The families want to appeal. They know that it's uphill in the courts, but they're determined to tell the story and to try to get information about what happened. But the courage that it's taken for those soldiers to come forward and the difference that it has made and will make in this case, and the ability to get accountability and truth about what happened has just been, speaks for itself. One point I do want to say, and I thought about this when I saw a t-shirt in the back that said, "Is it okay because Obama does it?" The attention that Stephen Abraham's declaration got when he filed that in court, and the circumstances were a little bit different. The Boumediene case was very big, it was huge. A lot of people were paying attention, but the outrage and the attention that that declaration generated about what was being covered up about the combatant status review tribunals, when I compare that to the fact that we have barely been able to get anyone to cover these accounts by these soldiers, for example, in this case about the deaths at Guantanamo, the contrast is really striking. And, the Obama administration has made known that they see accountability as somehow backwards looking, that they do not see a need necessarily to investigate the crimes of the past administration. And Joe Hickman and these other soldiers have gone to the Department of Justice. They have tried to get an investigation into what happened. It seems that their efforts have been shut down, that the administration is not interested in meaningfully looking into these allegations of murder. And so, we can speculate about why maybe they're just, in the mainstream press, has really been very little coverage. Anyway, so with that sort of, those thoughts, I'll turn to the case that Deborah mentioned that we brought. This is a case on behalf of the father of Anwar al-Awlaki, and it concerns the very publicly reported authorization by this administration to target and kill his son, who we believe is in Yemen right now, on the basis of an entirely internal, secretive, executive, bureaucratic process without any kind of external review, any kind of judicial review, any kind of a review that would be due to any U.S. citizen, regardless of the level of allegations that have been made against this person. There have been some strong allegations made, some inflammatory things said about how he may be the next bin Laden, senior leader of Al-Qaeda. Whatever the allegations are, they are allegations. And when I read those allegations, I think a lot about the cases of the men that I represented in Guantanamo, whose detentions had been found unlawful, and how after a court actually looked at those allegations, they found that they were incredible, that they weren't justified, that they were supported by evidence that had been coerced through torture or whatever. but how the government system of detentions has been crumbling as courts have been able to actually review the allegations. So I think, whatever you think about what's being said about this person, it's important to remember he's a suspect in their allegations at this point. There have been no charges. And the process that has authorized his execution, which normally should come after charge, trial, conviction for a capital offense, has been brought about through a process in the White House and in the CIA and in the Department of Defense on the basis of standards and criteria that we don't know. And, this case is about one person and one authorization that we know about, but the power that's being asserted and the authority that's being asserted is much broader and could cover any U.S. citizen. And one of the claims that we're making in the case is that U.S. citizens, pursuant to the Constitution, have a right to know, at the very least, the kind of conduct that could get someone put on one of these kill lists, that could get someone authorized for death. And the government is refusing to disclose even that. So that's sort of the basic outlines of the case. But separate from the details and the technicalities about the law, and I've spent a lot of time in the past few weeks writing legal briefs and getting into the kind of minutia. And when I was thinking about tonight, I wanted to step back a little bit and explain why we brought this case and why it's so important, separate from the legal technicalities and how it relates to what Ethan is going to talk about. And at a very basic level, and I think Ethan could talk about this, people who've actually served in war could talk about this. As generals in the Civil War have said, as Obama has said, war is hell. It's cruelty, it's destruction and devastation that has been happening in Afghanistan for 9 years, that's been expanding into Pakistan, and now the administration is trying to expand into other countries. This case is about trying to put a check on the authority that's being claimed by this administration to, on its own determination, declare that there is a global war against Al-Qaeda where suspects could be targeted wherever they may be, in Yemen right now, but wherever, the power that's being asserted is really wherever they may be. Not just even against Al-Qaeda, but what this case is about is someone who actually is alleged to be part of a group that is not Al-Qaeda, that is declared to be associated with Al-Qaeda. Well, how far do you go with the associations? What the facts show is that the particular group that our client's son is alleged to be part of is actually a separate and distinct group from Al-Qaeda, the Al-Qaeda that the U.S. is fighting in Afghanistan, yet the government is claiming the same authority to be able to target and kill him as part of this so-called global war against Al-Qaeda. And then separate from the power that the administration is claiming, they're also claiming unchecked authority. They're claiming that no court, and what we're trying to do now is just have a court review what's going on, review the justification that the government has come forward with for why they think they can authorize the killing of a U.S. citizen in a country like Yemen, where there are not thousands of U.S. troops on the ground, where there is not intensive combat between U.S. troops and an organized armed group, what the justification is for why they think they can do that, and have a court of law review that. And what the government is saying is that no court should even be able to review what they're doing. So at this level, where the case stands is we filed in court in August. The government has responded, and instead of responding and defending their position and explaining to the American people and the world why they think they have this authority and defending it on the law, they've come forward with a series of procedural, technical defenses that have nothing to do with the substance of the case or the substance of the authority they're claiming, and they're trying to kick the case out of court on these technical grounds. Like, one of the things they're saying is that our client who is the father of Anwar al-Awlaki.